Now, experience is the key to identifying that which is worth the fight and that which is not worth the fight. My first recommendation to all the young lawyers here is to get a mentor, whether it's in your firm or somebody in this room or some lawyer that you know. You know, there's a saying that says that you hire old lawyers and young doctors, and I really believe that. I think after 40 or 50 years of law practice, which I'm approaching, and I look out here and see other gray ball heads, we have a lot of experience that we've gained through hard hits. You know what I'm saying? And we can impart that experience to others. And I think the greatest thing that I can do is to help mentor another young lawyer. And the greatest thing a young lawyer can do is to seek out a mentor to ask what's important, what should I fight over, and what should I not fight over. Because when you go in, you're kind of like the lawyer in Crockett that I was telling you about. You want to fight over everything, and you shouldn't fight over everything. You have to have the discernment to know not what to fight over. So you got to know when to hold them, and you got to know when to fold them. Fair enough? It's just like the old saying. You got to know when to hold them, you got to know when to fold them. That goes on a lot of different grounds. It relates to when you got to know when to settle your case, you got to know when to try it. You got to know when to hold them, you got to know when to fold them. It also relates to arguing with the judge. Because many times you'll find out when you sit on the bench is they don't know when to fold. They'll sit there, you'll listen to them, you'll rule, and then you hear the argument continuously and agree. And we on the bench keep count. Fair enough? We on the bench know who it is that continues to do that. And not only do we know, but usually out of collegiality, that which exists between judges, we talk about you. And the judges will go get back there and say, you know, he had a good case, but God almighty, I just couldn't get across to him. He's sitting there arguing with me and arguing with me. Well, what's happened? When you do that, that judge has spoiled other judges. And that reputation that you were trying to gather has all of a sudden been infringed upon because you didn't know when to fold them. So don't argue with the court. Candidly admit your weaknesses while emphasizing your strengths. Good lawyers do that. It was such a pleasure. People ask me, what's it like to sit on the bench, on the trial bench? And I'll tell them, look, it's like teaching piano. They say, what do you mean it's like teaching piano? I said, well, there's a lot of tick-tock, tick-tock, tick-tock. And then all of a sudden, somebody will come in, throw the sheet music away, and just play a virtuoso. You say, God, money, was that great? You know, you're just overwhelmed by it. So you want to be the person that throws the sheet music away. You want to be in the memory of that judge. Oh, is that great music? And one of the ways you do that is when a judge asks you about a case and you know that case is dead against you, you admit it and then turn the subject as gently as you can, either shifting to another set of facts. But always, always admit your weaknesses, whether it's to your wife, your cohorts, your judge, your client, and especially to juries. And they tell you that in trial practice, don't they? They tell you the first thing you do is that you condition the jury to your weaknesses when you're voir diring a jury. You get your weaknesses across first. So don't always remember you got to know when to hold them and know when to fold them. Candidly admit your weaknesses while emphasizing your strength. Credibility with the court, credibility with opposing counsel, and credibility with your client is predicated upon your ability to admit when you're wrong and what your weaknesses are. Now, as I said, discovery fights are an indication of bad lawyering. Good lawyers don't have discovery fights. Good lawyers don't have discovery fights. Good lawyers know the rules. They'll call each other and say, look, here's what I need. I know it may have been worded a little wrong. You're right there. But here's what I'm really looking for. And a good lawyer will respond realizing, number one, it's discoverable. Number two, there's no privilege or other impediment to him getting it or her getting it. And they'll respond and get it worked out. It's bad lawyers that end up in the courthouse arguing over discovery. And that invariably held true through 10 years of practice. Because on the bench for 10 years, invariably bad lawyers have more discovery. My rule in practice is in requesting, be reasonable. In responding, absent clear authority, give it to them. And remember, in criminal cases, they have an open file policy. And that wouldn't be too bad of an idea in civil cases, too. Because if it's discoverable, then it's equal to being an open file. So in responding, give it to them. I currently represent a law firm that got sued. They're from Tyler. And I'll tell you, they're the hardest clients in the world to get them to admit to do this. They want to fight over everything. And then when I sit there and reason with them, they begin to understand. They even wanted to resist discovery of things that would help them, because they said, well, it's equally available to the other side. And I said, well, give it to them, and we'll avoid them having to go see it. It'll help us. So it's an issue of reasonableness. Fight the good fight over matters worth fighting. Now, sometimes you shouldn't compromise. Criminal cases of innocence, civil cases of principles and justice. Now, I want to go into pet peeve, if y'all forgive me, an old lawyer. ADR and mediation have their place, but not first place. 30 years I practiced law, and we didn't have to have marriage counseling to settle cases. 30 years I practiced law, and we'd get these cases settled remarkably. 30 years we went around, and good lawyers were able to settle good cases on a reasonable basis without the intervention of somebody else that we had to pay. Now in the last 10 years or 15 years it's become vogue to have mediation and ADR. You know, I think if we keep on going the way we are now, as I say in 2B, the question is going to be, instead of what would a jury do, it's going to be, well, what would a mediator award? Isn't that a ridiculous transition of where we are in the legal system? When I sat on the bench for 10 years, I never ordered a mediation unless both parties agreed to it. Unless both parties agreed to it. I think too many courts, and if I'm stepping on toes, I don't apologize because this is my feeling, I think too many courts appoint mediators because they're too lazy to try their cases, or they don't want to invest themselves in the trial of their cases, or they just want to get rid of it to reduce their docket. And I believe that the blanket appointment of mediators is ridiculous. It costs the clients money, it doesn't assist the system, and it doesn't help you as a sitting judge. At least I felt that way. Because I'd always have one lawyer come in and say, well, Judge, we really want to mediate. And I'd look to the other side and I'd say, do you want to mediate? And they'd say, no, Judge, we want to try the case. And I'll say, well, let's set. Because I believe that when you're going to, just like in marriage, when you're going to dance, you're going to have two people willing to dance. And if you have just one, you can't do it. So my rule is, when I practice law, is I never ask for mediation. Haven't done it in a year of practice. Not going to do it for the rest of my life. I never ask for mediation. On the other hand, if a lawyer wants to mediate, I always agree to mediate, because if the other lawyers are asking to mediate, then I know that we'll probably get the case settled. So that may be kind of a hard rule, maybe a hard-nosed rule, but that's my rule. I don't ever ask for mediation, but I never turn it down when offered. So the other thing that we as lawyers have to learn to do is to resist the considerable pressure to settle cases. You know, as part of this anti-trial and anti-lawyer rhetoric that goes around the state of Texas now, we've been forced into accepting, and we've subdued our own minds to accept the rhetoric that we're hearing on a continuous basis, and we've pushed ourselves into a corner of fear instead of into a corner of righteousness. And we as lawyers need to stand up for what is right. We as lawyers need to stand up for preservation of the jury trial, and preservation requires utilization. So, be proud of your profession, be proud to fight the good fight. There's a great quote by Vince Lombardi. I had it for 30 years. I had it hanging in my office. It's going to be again. I firmly believe that any man's finest hour, the greatest fulfillment of all that he holds dear, is that moment when he has worked his heart out in a good cause and lies exhausted on the field of battle. Isn't that a great quote? And he adds victorious. I would say just lying exhausted on the field of battle when you've exhausted yourself in a righteous cause.